Senior Designated Counsel, Advocate Mardikar, Pro-Vice Chancellor of Rashtrasanta Tukadoji University, Dr. Dudhe, the Head of the Academics of Postgraduate Department of Law University, Dr. Payal Thore, academic faculties, students, of course the office bearers of the High Court Bar Association. At the outset, I extend my gratitude, I extend my thanks to the organizing committee for inviting me for this seminar, which is based on the current trends, particularly about the developments in criminal justice and reforms and its intersection with the technology. I have decided to speak on the topics, I have rather segregated the topics which are to be dealt with in this seminar by each of the speaker, and I'll express my views on each of it. We, all of us, are now required to be upgrade ourselves with the technologies, and without technology it's not possible for each of us, an educated person, a person who is into higher education, to deliver to the requirement, to the level. Few time back when we were interacting with Dr. Payal Thore about the academic disciplines, the vacancies, the expectation of the students, it is informed that the students are more well versed to the technology, with the technology. And it's always expected from the students, and there is nothing wrong about it, that their teacher should be more and more well versed with the technology, including the academics. Perhaps this is one of the reasons why this seminar is being organized. I remember Justice Sikri, former senior judge of the Supreme Court, while dealing with an issue on the aspect of technology, has said that the education took us from thumb impression to signature. Technology has taken us from signature to thumb impression again. The criminal justice system is a system of various institutions that are involved in the procedure of bringing crime to justice. It is a set of laws, process, and institutions that aim to prevent, detect, prosecute, and punish crimes while ensuring the right and safety of the people. The legal system is a dynamic and multifaceted that continuously evolves to adopt the changing needs of the society. The criminal justice reform seeks to address structural issues in criminal justice system. There have been multiple criminal justice reforms in India, and some of the committees which were constituted were National Police Commission 1977 to study the jail reforms, police reforms. Then All India Jail Reforms Committee of 1980. Then Justice V.S. Malimat Committee aimed at increasing efficiency of criminal justice system. Justice Malimat Committee made recommendations which covered plethora of topics including investigation, trials, role of police, role of prosecution, and so on. Madhav Menon Committee was appointed by the Ministry of Home Affairs for reforming the criminal justice system, and its aim was to draft a national criminal policy to draft a national policy on criminal justice, which report was submitted way back in 2007. Now, perhaps these committees, the reform committees or their recommendations appears to have been based or which are studied for the purpose of enacting these new three enactment on which just now Mr. Mardikar has delivered a speech. A significant criminal justice reforms has been introduced in the year 2023. And then these three laws are enacted, that is the Nyaya Sanhita, then Bharatiya Saksha Adhiniyam, and Nagrik Suraksha Sanhita. This Bharatiya Nyaya Sanhita consists of 358 sections divided into 20 chapters. There is on the significance that one can note, in addition to what Mr. Madikar has said, is there are 18 new provisions and repealing of 20 old provisions in this statute you can notice. And it's compared with, rightly said by Mr. Madikar, compared with the old IPC. Some of the considerable highlights of this new law are that the community service has been introduced as the sixth form of punishment, and its definition has been provided under Bharatiya Nagrik Suraksha Sanhita. The definition of gender recognizes transgender within its ambit. The new chapter, that is chapter 5, which is added, it consolidates the offense against the woman and children. Three incomplete category of offenses, attempt, abatement, conspiracy, are brought together under chapter 4. Some of the new provisions which are introduced are section 48, that is abatement of offense committed in India by a person outside India. Then section 69, sexual intercourse on the false promise of marriage, employment, promotion, or by suppressing the identity, which makes it punishable. Then hit and run case have been covered under section 106(2) of the Act. Now this perhaps appears to be the basis for all these amendments and new additions. Perhaps is, as said, that these study groups or the committees which were formed to recommend the reforms in the existing colonial laws. A new category of offense known as mob lynching is also introduced, which is an aggravated culpable homicide. Section 304, new form of theft by way of snatching, and the major provision that of sedition defined under section 124A of IPC and offense under 309, attempt to commit suicide, have been repealed. The term gender neutral is the view where the policies, language, and social institutions should avoid distinguishing roles according to people's sex or gender. Gender neutral laws means all the laws and provisions of country are equal for all gender and are not favoring any particular gender. 172nd Law Commission report recommended that rape law must be gender neutral, and identical recommendations was made by Justice Verma Committee of the Gender Neutral Law for the victim, but for a gender specific law for the offender. Unfortunately, they weren't incorporated in new laws. As far as the Bharatiya Nyaya Sanhita is concerned, they have taken a small, rather I'll say a baby step in this direction of gender neutrality by replacing man with whoever in voyeurism and assault or use of criminal force to women with intent to disrobe. The Bharatiya Saksha Adhiniyam, which consists of 170 sections, is divided in 12 chapters. There is an insertion of 2 new provisions and a repeal of 6 old provisions as compared to the existing Indian Evidence Act. The crucial changes introduced are coercion is added as an additional ground under section 22, which deals with confession, which is irrelevant in the criminal proceedings. Section 39 widens the scope of experts to include those skilled in any other field. Last but not the least, Section 55 empowers judges to take judicial note of laws with extraterritorial operations, international treaties, conventions, or agreements. Bharatiya Nagrik Suraksha Sanhita, which consists of 531 sections, is divided into 39 chapters. It inserts 15 new provisions and repeals 15 provisions as compared to the old CRPC. The vital changes introduced which can be noticed in new law are bail, bail bond, and bond is defined. Similarly, the hierarchy in the trial judiciary, which we call the district judiciary, has been streamlined to the extent of the class of magistrate, then thereafter the session judges, and third is executive magistrate. As far as issue of arrest is concerned, arrest by a private person under section 40 makes him mandatory to produce such person within period